The top trial in the U.S. has controlled how state and social segment unions may no much longer gather charges of workers out of their agreement, a destruction for supporters of organized labor. The U.S. High Trial told such charges are unconstitutional and strengthen human beings to supporting ideas they may not trust. It told how violates at first correction rights by the U.S. Basic Law. The 5-4 judgment is anticipated to erode the social union's finance sustainability. The force of individual segment unions include shrunk in latter year, more than rather than a tertiary of social segment workers stay provided by a association. The organizations are a main strength in policy campaigns, characteristically offer supporting for the more democratic side. The instance was driven by Richard Janis, an Illinois country servant who was provided by a association, but did not wish to be a term since he objected to lot of its official position. By preliminary act, social segment unions could gather a fee of non-members for their services, stipulated the cash was not utilized in the direction policy activities and some ideologic job. An alleged 5 millionth non-union workers now pay such charges. In Mr. Janis's instance, the fee provided on 78% of the full dues, or more than rather than $500 every year. Unions include told such charges are essential, disputing they are significant due to complementary riders who would gain of the pay and some perks provided by unions on name of their members. In the most view, Judiciary Samuel Alito told concerns on complementary riders could not cancel considerations for the at first correction, and inverted a preliminary governing enabling the charges. The judgment was opposed by the trial's permissive justices. Judiciary Elena Hagen wrote, "Through the nation, the relationships of social employees and patronage will change in both of foreseeable and completely sudden ways. Judicial destruction does not get any more rather than which the trial does present." Richard Trumka, CEO of the AFL-CIO, that includes the US Federation of Country Shire and Public Employees, told the judgment showed the trial has conceded to the black web of corporations and rich donors who desire to get off the freedoms of work human beings. Analyzed by Natalie Sherman, the High Trial's judgment, that framework labor associations' rights to gather charges, is examined as behavior a potential deadly strike to the organizations. AC at the UK, wherever trading unions gather a individual fee of members to foundation policy activities, is enlightening. In 2015, by the government offered to changing the rules so how members would include to opt in to profitable the policy fee, quite rather than, as it now stands, outgoing them to opt out if they select. Opponents decried the schedule as an try to erode labor side finance. Really, a early experimental in such AA changing had caused a steep decrease in contributions. The period about the schedule was conquered. Yet, affiliation in UK trading unions is soaring close recording lows, offering the challenges cladding such organizations expand for their financing.